Back up, cuff up. Keep your burning if you cuff up. Come on, put your hands in. Your other hand.
During the month or so before this seminar, the local and national news media carried stories about a federal judge finding the state of California tortured prisoners, including by spraying inmates in the face with pepper spray multiple times just to administer their antipsychotic medication. See Coleman versus Governor of California, Department of Corrections and Rehabilitation, a 24-year-old case as of 2014. In New York, at Rikers Island, there were verified reports of jail guards handcuffing juvenile inmates out of the sight of cameras and severely physically abusing them. California was found to be violating the constitutional rights of prisoners by cruel and unusual punishment in violation of the Eighth Amendment. See Coleman. Accordingly, the San Francisco Sheriff's Department reneged on being a panel speaker, stating that they also used pepper spray. Dr. John Doucet, a psychiatrist who had been on contract with the California Department of Corrections and Rehabilitation for approximately 20 years, agreed to be a speaker, but did not show up or call to cancel. Notwithstanding the above, PWDF proceeded to have a public discussion on these important prisoner issues.
Thank you for coming to People with Disabilities Foundation Seminar, Part 2, Disability Abuse Against People with Mental and/or Developmental Disabilities, Jails, Prisons, and Law Enforcement. My name is Steve Egler, and I am a staff attorney at People with Disabilities Foundation. I am pleased to be the MC for today's seminar, which is the 14th in a series of educational seminars ranging in topics from multiculturalism to employment and education in the psychiatric and/or developmental disabled communities. People with Disabilities Foundation was founded 14 years ago with the mission of total integration of people with mental and/or developmental disabilities into the whole of society. PWDF is a Section 501c3 public charity based in San Francisco. Our primary focus is on psychiatric and developmental disabilities. In addition to seminars, we produce training videos for human resource directors and vocational rehabilitation counselors and CDs on subjects such as Social Security work and incentive programs in housing. Our other program component is a hands-on advocacy in 8 counties for representation in Social Security cases and education, employment, and healthcare and housing, as these areas relate to individuals' mental disabilities. Our founder and legal director, Stephen Bruce, has spent over 25 years as an advocate for these disabilities. He is a member of the California, Florida, and District of Columbia bars and admitted to practice before the United States Supreme Court. Today's topic is empirical evidence shows that people with disabilities, mental and/or developmental disabilities, are victims of violence at a much higher rate than the general population. Our first seminar in this series addressed abuse in the context of residential facilities and community settings. This follow-up seminar addresses disability abuse in the context of prisons, jails, and law enforcement. The percentage of people in jail or prison with severe mental illness is about 24% on average, much higher than the general population. This number does not include people with intellectual and other developmental disabilities, such as autism. Disability abuse can occur in the form of physical, emotional, or sexual abuse or neglect. According to the San Mateo County Adult Protective Services, physical abuse includes an intentional act that causes someone physical pain, injury, or suffering, and can include excessive forms of restraint. Emotional or verbal abuse is threatening, intimidating, or humiliating an individual and causing them emotional pain, distress, or anguish. It includes insults, yelling, and threats. Sexual abuse is sexual activity to which a person does not consent or is incapable of consenting. Neglect is when a caregiver intentionally or unintentionally fails to support the physical, emotional, or social needs of the person. This can include denying food, medication, health services, or contact with friends and family. We are honored to have several speakers today who have extensive expertise on the topic. They are Thomas Nolan, an associate at Rosen, Galvan, and Grunfeld, LLP in San Francisco. Mr. Nolan has litigated civil rights suits against the California Department of Corrections and Rehabilitation on behalf of inmates with mental disabilities. Our moderators today are Stephen Bruce, Legal Director, People with Disabilities Foundation, former Senior Staff Attorney, Social Security Administration, and HHS Office for Civil Rights, and April Banerjee, PWDF's Public Awareness and Education Program Manager, who is also an attorney. Mr. Nolan, our legal expert, will go over the legal framework that gives rise to the protections afforded to people and inmates in jail or prison or otherwise custody, including the Eighth Amendment's prohibition on cruel and unusual punishment, Title II of the ADA, and prohibition against the basis of disability accessing any service or food or program, including receiving medical treatment, etc. The Civil Rights of Institutionalized Act of 1980 is for state institutions as well as nursing homes. Volunteer compliance is a sought-after remedy under this statute. In 1988, the Memphis, Tennessee Police Department initiated the nation's first crisis intervention team in 2000, and in 2011, San Francisco used this model after an unarmed man was killed by the San Francisco police in front of the county's Behavioral Health Service office. CIT is for pre-arrest jail diversion for those in mental health crisis. This program provides law enforcement-based crisis intervention training for helping those individuals with mental illness. And thank you for coming and participating in this important discussion. With that said, I will pass the microphone to Stephen Bruce, PWDF's Legal Director.
Thank you, Stephen. I want to introduce Tom Nolan first to set forth a legal framework mostly for the Coleman case, which I understand was going on a very long time, perhaps 20 years.
24 years.
24 years. We've heard about overcrowding in state prisons in California and also in other states. Apparently, there is a very noticeable disparate impact on those with severe mental and or developmental disabilities as it relates to taking disciplinary action, receiving treatment equally for physical as well as mental health, and the repercussions from taking disciplinary action, whether it be in the form of tasers, pepper sprays, or other actions for an inmate's apparent refusal not to follow instructions. They have to follow instructions, and if they don't, traditionally the prison guards and other officials take what they believe to be appropriate punishment or disciplinary action. So part of what Mr. Nolan will discuss is cases, especially a case called Coleman versus Governor Brown relating to the California Department of Corrections and Rehabilitation, when certain corrective actions or disciplinary actions rose to the level of violations of the Eighth Amendment, which prohibits cruel and unusual punishment. Mr. Nolan?
Thank you, Steve and Stephen. The Coleman case has actually been going on for a very long time. It's 24 years old, and our Judge Carlton, just recently retired. We have a new judge. Part of it is just that it's a very complex institutional reform case with a lot of different parts, and it takes a long time to fix them. So I'm going to get to that. I'm going to start by talking a little bit about just the huge overrepresentation of the mentally ill in our prisons. I'm going to I'll tell you a little bit about my background. Then I'm going to talk to you, as I said, about the overrepresentation of the mentally ill. Then I'll talk about the Coleman lawsuit and give you an overview. And then I'm going to focus on why prisons are such a bad place for the mentally ill. I think we've had in California a fairly unique experience. This case has gone on so long that we've really gotten to know the prison system very intimately as plaintiffs' lawyers representing mentally ill prisoners. And so the problems with barriers to treatment, the problems with use of force, problems with overuse of segregation and different forms of punishment are probably the things that will come up late in a long-term case like this. And those are the issues we've been focusing on lately. So I will talk about that. I'll talk about some motions we filed. We were in court all year last year trying to address those major problems. And then I'm going to talk a little bit about just the need for all of us who are advocates and who care about the treatment of people with severe mental illness, the policy issues that we need to work on outside of the legal system, because there's limits to what the law can accomplish in reforming some of the problems I'm going to talk about today. My experience and my primary expertise is that I've worked on the Coleman case now for 21 years. And I spent a lot of time in Coleman was, the trial was finished when I actually arrived at my law firm in 1993. So most of my career has been spent trying to get this huge, complicated institution that treats many or maybe most of our most severely mentally ill people in California to really fix all the many problems it had providing mental health treatment. I've also worked on a number of other prison conditions class actions. In California, particularly in the Armstrong lawsuit, which is an ADA case about prisoners with physical disabilities, mobility impairments, hearing impairments, vision impairments mostly. That case, we've actually been the monitor, so we spend a lot of time in the prisons, interviewing prisoners, interviewing staff, touring prisons. And so I've probably, in my 21 years, done approximately 225 to 250 monitoring tours, some of them multi-day. I've visited 27 of the 34 California prisons and toured them. And I've probably interviewed thousands of prisoners and thousands of CDCR staff. I also recently got a master's in psychology at UC Santa Cruz. I was studying with Craig Haney, who some of you may know. He's a very prominent expert and advocate for prisoners' rights, who's done a lot of work about the impact of solitary confinement on prisoners with mental health issues. So I just want to start with some prevalence information. So in 2012, the prevalence rate for individuals with serious mental illness in the US was about 4.1%. The most recent figures I have from the Coleman case for the prevalence in California prisons is that there are approximately 36,000 prisoners with severe mental illness. It's about 26.6%, some estimates as high as 28.5%. depending on how you do the counting, of all the prisoners in California. So that's an extraordinary level of overrepresentation. The mentally ill are overrepresented about 6.5 times in the prison population, which is actually quite similar to the rate for African American men, who I'm sure many of you know are also terribly overrepresented. African Americans in California are about 6% of the population, and they're 29% of the prison population. So the mentally ill are equally overrepresented, suggesting that they also are experiencing a lot of bias in the judicial system. The question of why our prisons have become mental hospitals is probably familiar to most of us, but it's worth just going over a little bit here. Starting in the 1960s, we went through this process of deinstitutionalization. It was a process that was sped by concerns about these large mental hospitals that were legitimate concerns. But the hospital population dropped from about 35,000, 36,000 in the late 1950s to about 5,000 by 1980. The idea was always that we would move people from these large institutions into community mental health. And of course that didn't take place because we never really funded community mental health programs sufficiently. Another factor, I think, in the large number of mentally ill prisoners in California has to do with the criminalization of the mentally ill. And I think that this has gained some momentum in recent years since September 11th. There are new terrorist threat laws that carry very heavy-duty penalties that have disproportionately impacted on psychotic mentally ill individuals and mentally ill individuals who are paranoid also, I think, have gotten caught up by those laws. There's also just a focus on kind of quality of life crime policing, modeled after the New York City Police Department. It's been imitated widely around the country. And it ends up, I think, picking up a lot of low-level offenders, including a lot of mentally ill individuals. And then I think there probably has been some targeting of the mentally ill homeless by police around the state. I also think vagrancy laws, which were either not enforced or were being repealed around the country in the 80s and 90s, have sort of made a comeback, and California actually has vagrancy laws in many parts of the state. So I would recommend, there's a very good report about this issue called "When Did Prisons Become Acceptable Mental Health Care Facilities?" that Stanford Law School just released this May, along with Senator Darrell Steinberg, a state senator, which looks at this history and has some important findings. One is that in the last 15 years, the number of mentally ill in prison in California has doubled. Another important finding is that the mentally ill receive longer sentences across all felonies. And so this slide, I think, illustrates that, for most crimes, people with serious mental illness receive significantly longer sentences. Which I think suggests that there's some stigma and bias at work in the criminal justice system that we all need to try to address. The study also found that, I probably need to give you a little background here about Proposition 3036. So California has a 3 strikes law that is extreme by national standards. And the law, when it was passed in 1994, allowed a 3rd strike conviction and a punishment of 25 years to life for minor felonies like shoplifting, petty theft with a prior, until Proposition 36, which reformed some of that, passed in 2012. There were 350 people serving sentences of 25 years to life for petty theft. There were about 600 people serving 25 to life for simple drug possession. And there were about 400 doing 25 years to life for receiving stolen property. So Stanford Law School has a policy center and some clinics that were very involved in trying to reform three strikes. They initially represented a bunch of people who had been convicted for minor offenses and got them resentenced in habeas actions, and then they put together Prop 36. And one of the things Prop 36 provides is that you could go back and resentence people who were sentenced under the three strikes law. And one of the things that shocked them was their experience was that the mentally ill were doing very badly. We're often getting resentenced back to complete this 25-year to life sentence. The report also discussed higher recidivism rates overall for individuals with mental illness. And then it talked about just the sort of risk factors, what we call criminogenic risk factors for the mentally ill. This chart shows that for things like homelessness, a history of physical or sexual abuse, foster home when you're a child, or having parents with substance abuse, the mentally ill individuals with mental illness are significantly more likely, to have those risk factors. So I want to shift and tell you a little bit about Coleman. So Coleman is somewhere between 36,000 and 38,000 class members with serious mental illness. Anyone receiving mental health treatment in the California Department of Corrections is automatically a member of the class. The Department of Corrections has called its mental health system the largest mental health system in the world, and I think that's a plausible argument to make. Interestingly, the LA County Jail often says that about their system, but I do believe the LA County system is smaller. The Coleman case, as I said, is 24 years old. The judge who was with the case since 1990, Judge Carlton, has retired just this year, and we have a new judge, Judge Mueller. The case has been in the monitoring phase with a court-appointed team of experts and a special master since 1998, so for about 16 years. Starting in around 2007, my firm and the prison law office, our co-counsel, went to court in two long-standing cases that have to do with care for prisoners. One is Coleman, which is about mental health care, and the other was Plata, which is about medical care. And in 2007, the department was so overcrowded that Governor Schwarzenegger at the time issued an emergency proclamation talking about how dangerous this overcrowding was and all the associated problems. And so we went to there's a special process if you want to get a cap on population in a prison, or if you want to reduce population in a prison, you have to go to a specially convened 3-judge panel. So we did that. And in 2009, the panel ordered the state to reduce its population from 200% of its design capacity for its prison system to 137%. And that case actually went all the way to the U.S. Supreme Court, and we won. And so that process of reducing the population to a size that the Department of Corrections can effectively manage and provide appropriate medical and mental health care is currently underway. One of the things that's happened as the population has been reduced is that the overall population has dropped much faster than the population of mentally ill individuals. And in fact, so this is the population drop for overall. And so at the peak, it's hard to read the number, the scale here, but at the peak, the population was about 172,000. And by 2013, it was down to around 135,000 prisoners. The population for the mentally ill peaked around probably 37,000, and then it dropped to about 34,000. And now it's probably back up to 37,000. Just in the last year, it's gone to a new high. This chart ends in September of 2013, I believe. So last year in January, the governor, I think in part because of these overcrowding orders, moved to terminate Coleman. And so we hired a bunch of psychiatric experts. We toured 12 prisons with them. We did discovery and reviewed thousands of pages of documents. And we defeated the motion to terminate. And then we moved affirmatively. We moved in 4 different areas for new enforcement orders from the court. One was about inpatient hospital care. So in the Department of Corrections, the highest level of care has always been provided by the Department of State Hospitals. It used to be provided in Atascadero and Patton, and to a certain extent, Napa state hospitals. But in the last 15 years, they've built standalone, separate programs inside the grounds of a couple different prisons, including Salinas Valley and the California Medical Facility in Vacaville. But so there were serious problems with understaffing, lack of supplies, lack of group therapy. There were severe custody restrictions. So that was one issue that I'm not going to talk much about today, but that we won a new enforcement order about. We also moved to ensure that there was complete care for the 700 men on death row at San Quentin who didn't have access to the highest level of mental health care. There was no intermediate inpatient program available for them. There was some access limited to the acute program at the California Medical Facility, but there were serious problems with that program as well. So we also won that one. And then the two I'm going to talk a little more about today is we filed a motion about the use of force against mentally ill prisoners, and we filed a separate motion about the overuse of segregation units. Segregation units are punishment units where they're sort of prisons within a prison. So if you commit a rules violation in prison, you go to a segregation unit, and those units are places that can be very violent. They're places where you're locked in your cell for 24 hours a day. Sometimes maybe it's 23 hours a day if you're lucky and you get exercise. But they tend to be very toxic places for the mentally ill. And we, for instance, when we were working on the termination motion, we were able to go with our experts into these units, and very often we would find psychotic mentally ill individuals who are not being treated and not being moved appropriately to a higher level of mental health care. So I'm going to talk a little bit about just what the care program in the Department of Corrections looks like. So starting actually at the bottom of this slide, I have just general population, meaning people who don't get any mental health care. The lowest level of care above that is triple CMS, and that's stands for Correctional Clinical Case Management System. And that's a system of, it's actually a little bit like what outpatient care would be in the community. It's a system of mostly medication management. Occasionally there'll be a little bit of therapy groups, and a meeting with a case manager probably every 60 days or so, and a meeting with a psychiatrist probably every 60 days or so. The next level up is and that triple CMS is probably about 28,000 of the mentally ill prisoners in the system. Excuse me. The next level up is EOP. EOP programs are enhanced outpatient programs, and they are structured and sheltered living units, so they're separate from non-mentally ill prisoners. And there's much more intensive treatment, including about 10 hours a week of therapy groups. And then I already mentioned inpatient hospital care. There's a couple different levels of acute care. These are just some numbers for each level of care. There's intermediate inpatient care in the hospital, which is the longest term care, and that's what originally that was provided at Atascadero State Hospital, and people would stay there for a year or more. There's acute care, which is more like an infirmary care unit for 30 to 45 days, and then there's 10-day units called mental health crisis bed units that are licensed correctional health care units in about half the prisons. So in talking about discipline and use of force and abuse of prisoners, that one area of concern is just the overrepresentation of prisoners with mental illness in the punishment units within the prison system. So as of September, mentally ill prisoners were about 42% of the population in these units, in these punishment units. So that's significantly above the 27 or 28% prevalence rate. And then SHU units are special long-term punishment units that California uses much more than perhaps any other state. The most famous one is the Pelican Bay SHU up in northernmost California. And that's a very severe, very high security prison that has, the cells have no windows. They're designed to impose sensory deprivation on the prisoners who live in those units. And actually, in both Coleman and the Madrid case, people who are EOP or higher, and also triple CMS people with certain qualifying mental health conditions are excluded. But there's something called a psychiatric services unit, which is actually a SHU unit for those mentally ill people. It's not that they are sort of excused from those long-term punishment units. They just go to one where there's a lot of mental health care brought in. But they still spend a lot of time isolated in their cells. So in the SHU units and PSU units, the population of mentally ill is a little bit less, there's a little less overrepresentation. It's about 36%. I just want to say a little bit about California, in particular, being a bad place for mentally ill to be prisoners. California is an outlier in many ways in terms of sort of basic measures of safety and compassionate care for prisoners. The suicide rate, these are Bureau of Justice statistics based on a report covering the years 2000 through 2011, so an 11-year period. The suicide rate in the CDCR has consistently been about 140% of the national average. The drug overdose rate in California is off the charts. It's 300% of the national average over that entire period. And I can talk a little more about why that's so. And then, for many years in Plata, the medical care case, the experts documented that there was probably about one or more preventable death due to medical neglect or poor medical care. Hopefully that number has gotten better in the last few years. I expect it has gotten better. And then as far as high murder and assault rates, the same Bureau of Justice Statistics report found that the homicide rate in the California prisons was double the national average for those 11 years. And then in 2006, the Nonpartisan Legislative Analyst's Office in Sacramento, which issues really good reports on a lot of issues, looked at assaults in California in two systems of similar size. They looked at Texas, and they looked at the Federal Bureau of Prisons, which had about the same number of prisoners at that time. And the California prisons had 200% the rate of assaults of Texas and 300% the rate in the Federal Bureau of Prisons. This should be number 3. So another issue in California that's unusual is California's prisons are very locked down. The prison administrators would probably attribute it to gangs being particularly severe in California. I think plaintiffs' lawyers like myself probably feel it has more to do with a kind of custodial mentality to lock down for excessive periods of time and for overly broad reasons. But the typical lockdown would be that there's a fight on a yard at a prison, and it involves prisoners of two different races, perhaps, and the prison would lock down that yard, so no one would go out to eat in the dining hall. No one would leave their cells to go to work or to school or to mental health treatment. And those lockdowns, because they impose a kind of isolation and a kind of purposeless isolation at that, those lockdowns tend to be very toxic for people with serious mental illness. The prison law office, our co-counsel, has filed a suit about race-based lockdowns, which I believe has been settled. But that suit alleged in great detail this pattern of locking down the prisons, and there were lockdowns that had lasted for years and years and years, and with very brief interruptions. There may have been lockdowns at some prisons for a decade. But just to take one snapshot, there was another LAO report that looked at a 9-month period in 2006, and they found there had been 600 lockdowns, including 100 lockdowns lasting more than a month and 37 lasting more than 3 months. Another issue is that the CDCR, which added the word rehabilitation to its name in 2004, and subsequently has consistently cut its rehabilitation programs, that they really have kind of decimated their education and substance abuse programs. They have actually, one good thing that has happened in the CDCR is they've permitted a lot of outside groups to come in and provide educational programming and other kinds of programming, but their own programs at that same time have been slashed. So in 2008, the LAO found that only 7% of the 110,000 prisoners reading below a 9th grade level were in remedial education programs. And then, in 2010, the number of substance abuse treatment beds was cut from 12,000 to about 2,500 beds. And then in 2012, it was cut further to about 1,500 drug treatment beds. And this is at the same time that the rate of death through drug overdoses in California is about 300% of the national average.